Former President Donald Trump back in court, well, virtual court. Today, Trump appeared virtually in a Manhattan court so a judge could ensure Trump understood the terms of a protective order imposed last month. Now, Trump pleaded not guilty to 34 felony counts of falsifying business records. The payments were allegedly payments to adult film actor Stormy Daniels. According to the protective order, Trump is prohibited from posting on social media any evidence turned over by the Manhattan District Attorney during pretrial discovery. The order was requested by prosecutors after Trump criticized Manhattan District Attorney Alvin Bragg and the presiding judge, Juan Merchan, and others associated with the criminal case. Judge Merchan imposed the protective order over evidence, but did not impose a gag order as to what Trump says. Merchan says he wanted to give Trump the freedom to speak about the case as he campaigns for president. Judge Merchan has set the criminal trial date for March 25th, 2024. Harvard Law Professor Emeritus and author of the book, Get Trump, Alan Dershowitz joins me. Good evening, sir. And it's sort of interesting. He doesn't want to give the president a hard time during the campaign for president, but he sets the trial date right smack in the middle of March, which has all the primary dates. So I don't know. Maybe he doesn't have a Republican primary calendar in front of him. But your thoughts about the judge's ruling on the evidence, the protective order?
Well, I think the First Amendment certainly, and the Sixth Amendment, protect Trump's ability to go out and defend himself in the court of public opinion. But the judge is within his power to restrict anybody from disclosing material that's under seal or material that's for his eyes only or his lawyer's eyes. But, you know, this is part and parcel of a whole attempt to silence him. We have the case now in which Carol is piling on, trying to increase her damages in the lawsuit because of what he said after the jury verdict. Surely any American should have the right to defend himself or herself against false accusations or accusations he believes false in the court of public opinion.
Let's explain what this in every criminal trial, the prosecution has to turn over evidence to the defense of what it expects to prove at trial, right? I mean, the defendant gets to see that's evidence going to be used against him. So Trump gets to see that evidence, but he can't like put it on the internet. But what's to prevent him from looking at it and saying like, oh, here's an email from so-and-so that says I did such and such. He's not putting it up, but since it's not a gag order, it's about the physical evidence. Any problem with that?
There's no problem with that as long as it's not under seal. There may be some discovery that's given to a defendant that is not available to the public. Just discovery that won't be used at trial, but might be used to help develop evidence at trial. And so some restriction on publicizing.
Like what? In this case, like what?
The name of another woman, for example, who might be used by the prosecution in presenting further evidence.
Well, that's the last thing I think that Trump would want to reveal. I mean, if there is someone like that, I don't think that would be somebody that Trump would want to reveal anyway, if there is another.
Unless she was making a false statement. If he can prove it was false, he might want to reveal it. But in any event, it's not a question of what he'd want to reveal. It's the judge has an obligation to protect innocent people, but judges go too far. And I think the judge right now tried very hard to split the difference and allow him to say what he wants in a campaign. There are other judges who would have tried to restrict even his ability to proclaim his innocence. And I'm concerned in the civil case that we may see the judge in that case, Judge Kaplan, who's already hinted that, he might allow damages to flow from a repetition by Trump of his claim of innocence. Every American should have the right to proclaim their innocence, even in the face of a jury verdict. And of course, in that case, it could backfire because Trump perhaps could sue Carol saying, aha, the jury said I didn't rape you, and now you're saying I did rape you, so I'm going to sue you for that. Look, it's so much better to let it all be out there and let it be judged in the court of public opinion. These are people running for president, the most important job in the country. We ought to err on the side of allowing more information to come out.
In that case, and I agree with you, it should be all that he can even release the physical evidence, the documents, unless that the prosecution specifically asked that something be put under seal. Very restrictive, rather than, I think the judge's order is overly broad and steps on the president's rights, the former president's rights. But it's one thing if the prosecution says this shouldn't be out in the public domain and makes a specific motion to put it under seal, you know, this expressed document or evidence.
No, I agree with you. I think unless it's put under seal, the defendant should have the right to publish it to the public and use it as part of his claim of innocence in the court of public opinion, especially since he's running for president and the case is going to be tried in the court of public opinion. You know, you say the case is scheduled for March. We know cases don't go forward when they're scheduled. It could be even closer to election than that, and the president has to be free to defend himself.
Alan Dershowitz, thank you, sir.